All right. Hello, good evening, good afternoon, good morning, wherever you may be in the world. My name is Chris Campbell. As you can see there at the bottom of your screen, I am one of the co chairs of Racial Equality for Arbitration Lawyers, otherwise known as REAL. And it is a pleasure to be here with you. For me, it's actually evening time. I'm joining you all the way from the far reaches of Hong Kong on the other side of the planet from where many of you may be joining in. But nevertheless, it is an honor and esteemed privilege to be here with you today on this important topic of bias in international arbitration, a topic that I feel that all the speakers that you're going to hear from today work in international arbitration, along with myself. We have a moderator and several speakers that are going to address you here in just a few moments, and they'll do their introductions. In fact, if we were to do them all in their full esteem, it would certainly take more time than we have today. But before we get to that, I want to share some welcome notes with you. When I think about a topic like bias in international arbitration, it brings me back to one of the first cases I worked on when I started at Baker Hughes. I recall it specifically because it was such a striking instance. I was sitting second chair with our head of litigation, a woman named Teresa Garcia Reyes, who's our head of litigation now, that sits out of Houston. And we were sitting in a negotiation with another party. It was a mediation, and during that mediation, it was a hard-fought discussion back and forth. And we noticed several times throughout the discussion, whenever there was a point coming from our side, from the company side, the mediator would always ask me, the second chair, the person that come in relatively late to these discussions. And as we would have our caucus sessions, we would kind of notice that, why is he talking to Chris? Why is he asking Chris as if Chris is the only one that can speak on behalf of the company or knows anything about the company? It got to such a point that Teresa went to make a point during that presentation, and the mediator kind of very sharply cut her in the middle of the conversation. He says, "Well, Teresa, we've already discussed that. I don't think it's important to talk about that point anymore." It was completely out of line, inappropriate, and not a way that he would have spoken had he been speaking to me. At the end of the mediation, after we were discussing, after mediation had failed, we were talking about that comment and that remark, that moment, that it sort of shifted how we felt about the mediator and our ability to trust that he could communicate our message effectively. And my boss, Teresa, went and talked to the mediator, asked him specifically, Mr. Mediator, that moment that occurred during the middle of our caucus session, I really didn't appreciate that. And I thought that language was inappropriate, especially for me as the lead counsel in this case. Mediator says, "Oh, I'm sorry. I thought Chris was the lead counsel in the case." Why? Why would you think that? The person that's come in the latest to the case, that had not said very much, that was just, in fact, making only sort of reserved comments here and there. Now, in fact, this mediator had other issues too. As it come to find out, when he didn't know who I was, not only did he assume that it was me, the man, that was the one leading the negotiation, but he'd actually asked the other side who I was too, which raises all sorts of other ethical issues. But it's an important question that comes to mind. In this day, even in the 2010s, 2020s, we still are having issues like this when it comes to bias of all types, whether it be gender, racial, ethnic, cultural, LGBT sexual orientation, any of these types of issues that we might find when it comes to dealing with these types of subject matter in international arbitration. Now, that was a mediation, but I can assure you these things occur in arbitration as well. And so where does that leave us as we prepare here for these comments today? Just across in my home United States of America, we have situations where the highest court in the land, the United States Supreme Court, has apparently decided that something like affirmative action is no longer fit for college universities to be applied. From there, you also see activist law firms suing other law firms and other institutions in the United States, not just to have their agenda pushed, but to strike down any vestige of affirmative action, which is meant to be an equalizer for affirmative act for racial and ethnic bias and discrimination in the United States. So where does that leave us? What can we do? I would say, and I think what you'll hear from the panel today, are some specific actions that can be taken. We can understand and define what diversity means in the context in our current practice of international arbitration, what bias is, what it looks like, and how we can be part of that solution. I think we all have a role to play in that, and that's what we endeavor to do here at Real. So I've already taken a decent amount of time sort of setting the stage here, and I'm excited to hear what our panelists have here to say. So I think I'm going to turn it over to them. Again, warm greetings from Hong Kong. I look forward to seeing each of you hopefully sometime soon in person. And as I tell folks, if you should find yourself in Florence, Italy, where I sit for Baker Hughes, or perhaps even in Lisbon, Portugal, feel free to say hello, and we look forward to working with you here at Real. So Dr. Yagmir, I turn it over to you to introduce the panel. And panelists, thank you so much for being with us today. Thank you.
Thanks so much, Chris. I know that it's very late there, so I thank you, and I say good night, and talk to you soon. Thanks very much. Good evening, good morning, and good night, wherever you are. I'm very happy to moderate this session. My name is Yağmur Hortoğlu. I'm a lecturer in law in Maynooth University in Ireland. We will discuss a very important topic today. We will start with the speeches, and then at the end we will have a Q&A session. So if you have any questions throughout the event, please take a note of it, and you can also share it on the chat box here. And I will select some of them, and at the end I will ask them to our speakers at the end of the session. So I'm joined today by stellar speakers. Our first speaker is Professor Dr. Won Kidan. Professor Dr. Kidan is a full professor of law at the Villanova University Charles Widger School of Law and the director of the South Africa program. Before joining Villanova Law, he taught at Seattle University School of Law and Penn State Law. Prior to joining the legal academy, he practiced law in Washington, D.C. His areas of expertise include international arbitration and litigation, comparative law, and the legal aspects of China-Africa economic relations. He is the author and co-author of several books, law review articles, and book chapters. His new book, by the way, on Africa's international investment law regimes will be published in November. Professor Kidan will be addressing today cultural bias in international arbitration. The floor is yours, Professor.
Thank you very much, Yagmir. I appreciate the invitation. Good afternoon, good evening to all of you, wherever you might be. My topic is cultural bias in international arbitration. Before I begin talking about it, I'd like to sort of set the stage in providing context where I come from to this topic. In my recent book that was just kindly mentioned earlier, I profile 30 of Africa's investment dispute cases. And what I found was 88 arbitrators decided 30 cases. These are all cases published in English. And of the 88 arbitrators, about 80 of them were actually European or North American, and there were only 4 women. And that is not a very diverse pool. So what's wrong with that? It's very difficult to say what exactly is wrong in terms of each individual case. I come to various conclusions that that's not what I'm going to be talking about today. We're talking about cultural bias. The typical case involves a European contractor implementing a European financed project in Africa. The dispute is resolved somewhere in Europe, whether it's in Geneva, in Paris, or in London, and all the African parties must appear before that tribunal represented by various types of law firms. So the question that we're asking is, what is the role of bias, primarily cultural bias in this context, in the actual proceedings? So conscious bias is simply corruption. There is no solution in discourse. Unconscious bias is a form of ignorance, and that is what we would like to address. Now, it's more acutely felt when there is uncertainty in the facts, ambiguity in the law, and discretion in the application of the facts to the law or the law to the facts. Now, if you can see my slides, I begin with structural, macro level bias, institutional assumptions on competence, and individual bias. These are the three topics that I'd like to address. I'm mindful of the 10 minutes that I have. Structural bias, by this, what I mean is structurally, by their very nature, whether it is treaty based claim or contract based claim, there's a concentration of all of the major cases in particular centers in Europe or sometimes in Washington when it's a treaty claim. When that happens, right, it limits the pool of arbitrators to persons who are qualified to practice or are competent in these jurisdictions. Many of the major infrastructure project contracts or other types of major contracts, they allow one of the parties to nominate one of their arbitrators, but the default appointment authority always resides in one of these major centers. The institutions, whether it is ICSID, whether it's ICC, LCIA, or increasingly when we go east, whether it's CTAC in China, those are the appointing authorities, and the appointment of their chair is the most important determinant of the outcome of the proceedings. So if these institutions are selecting chairs from among those that they are familiar with, there's already that built-in structural disadvantage to those that are considered outsiders. That is the structural institutional bias that I'm concerned about. The institutions themselves, because of their historic origin and their views on what laws and procedures ought to be or how they apply, there's this immutable sense of what is right and wrong that is transferred through generations, through legal training, institutional exposure, and all of that. And if you complete that circle, the selection process is already that way. And there's no surprise when I mention the statistic that I mentioned to you earlier. Now, at the individual level, bias is a gap filler. And as I said earlier, when the facts have uncertainty, and of course, assumptions come in. And the key component is the finding of credibility in the evidence. And we know from the science of persuasion, there's tons of studies that people generally consider those that are similar to them to be more credible than people that they don't understand. There's that individual bias that actually fills the gap, whether it's in the fact or the ambiguity in the laws, as I mentioned. Now, just an example. Someone trained in the common law legal tradition may consider testimonial evidence or give it more credence based on their perception that they can, through cross-examination, find out what exactly happened, may be more inclined to focus on testimonial evidence than documentary evidence, someone trained in the civil law legal tradition. This is very well known. It's not very nuanced. Everybody knows this. But deep inside, within each legal tradition or within each training, when the witness is an outsider that they're not likely to understand because of various things, cultural background, it includes all sorts of things, including where the person is from, origin, culture, language, and all of that. So in each individual case, the arbitrators, particularly the chair, needs to make a decision whom to believe and whom not to believe. If there is a shortcut in cases of uncertainty, that one is preferred over the other, then of course the outcome is determined that way. And it's not always obvious. Why? Partially because bias is not 100% objectionable. The party who prevails mostly appreciates it, enjoys the privilege. So it's extremely difficult to identify, even for those who are making the decision. That's why I started by saying, we're not talking about conscious bias. That is a form of corruption. It's unconscious bias that we are most concerned about. So We know that bias, vicious judgment, we know it exists. I don't think there's any dispute about that. So what do we do about it? Do we legislate and eliminate it? We can't. There are several steps at the micro level that we can take to minimize the harmful effects of bias. Try to outline that and conclude. So addressing the bias, everybody has a role. The institutions, they can be extremely careful in who they select for that particular case. And I don't want to go through each one of these points, but I'd like to focus on just a few. And the parties themselves in drafting the arbitration agreement can be more specific as to whom they want the appointing authority should be. That's the most important element. If they just default and sign a form contract without reviewing it, then that becomes part, and they contribute to the problem. The institutions, most importantly, have to be extremely conscious of these issues. They have to screen people better. They have to check everyone. They have to train people on unconscious bias. So they have all sorts of responsibilities in terms of the appoint. And the advocates, I think most importantly, the advocates have to recognize that there could be bias on the tribunal. And they have to use all of their persuasive abilities. They have to be acquainted with all sorts of literature that talks about how to actually be able to address issues of bias in the argument itself. And they can play that role, and they have to take that obviously seriously. So it's an aspect of persuasion. And the courts, obviously, whether they are reviewing the matter for annulment or enforcement, and it's an aspect of due process. A judgment that's vitiated by bias should be looked into very carefully by the courts also. Finally, and I think this is an important solution, I advocate all the time that awards should be published in important cases. There's no better check and balance than making awards public and attributing opinion to particular arbitrators and keeping track of those. With that, I come to the conclusion. Thank you very much, and I'll be happy to answer any questions that you may have.
Thank you very much, Professor Kidan. It is a very important topic and a very important perspective, actually, and I'm sure there will be a lot of questions. And there are actually a lot of issues surrounding this topic. Thanks a lot. So our second speaker is Ledea Sabadogo-Lewis. Ledea is a French-English bilingual lawyer. She's qualified in New York, and she's actually currently based in Paris. She specializes in commercial and investment arbitration with a focus on Africa. Ledea has recently been included in the Legal 500's Private Practice Power List 2023 for arbitration in France. She's a member of AfriCARB and also heavily involved in Hogan Lovells Paris-Afrique group. Ledea actively monitors developments on the African continental free trade area and publishes widely on the topic. She also publishes on developments involving international arbitration on the African continent and contributes to pro bono projects involving international human rights and international law matters. Ledea will be addressing today the African perspective on bias and diversity in international arbitration. The floor is yours, Ledea.
Thank you very much, Yagmor, for your kind introduction. I'm very happy to be amongst you and my co-panelists today to address such an important topic as bias and diversity in international arbitration. So many thanks to you, to the Real Network, and of course the Arbitration Channel for broadcasting this event. I myself, I'm from a pretty diverse background. My father is from Burkina Faso. My mother is Canadian. I've grown up between Mali, Rwanda, Burkina, Canada, and the US. I'm also trained in diverse legal systems. I've attended American law school, but then, as you mentioned, moved to Paris. And so in light of my background and as part of my role here at Hogan Lovells over the past 5 years, I've been very involved in developing our Paris-Afrique desk, which is a cross-practice team in our Paris office, which focuses our expertise on the African continent. And this is why I have decided to focus my presentation today on providing a bit of an African perspective on diversity in international arbitration, which will be complementary, I think, to what Professor Kidan has discussed, because both, of course, are intertwined, bias and diversity. So by way of introduction, I'd like to start off with just a few statistics to describe the current state of affairs. According to the latest statistics from the International Center for the Settlement of Investment Disputes, ICSID, which were released in January of this year, ICSID arbitrations involving at least one African state have amounted to about 25% of all cases registered since its creation in 1966. In contrast, we have only 7% of arbitrators that were appointed that originated either from Africa or the Middle East. If we narrow this down further to sub-Saharan Africa, which I will focus in more detail on, there were 14% of cases that were filed involving a sub-Saharan state from 1966 to 2022, whereas only 2% of arbitrators appointed from the region. Similarly, and to a lesser extent, the latest publicly available ICC statistics reflect that in 2020, only 1.2% of arbitrator appointments involved an arbitrator from sub-Saharan Africa, whereas almost 7% of cases registered that year involved a party from the African continent. So I think this is a good introduction to show that there is room for more inclusion and representation across the different regions of Africa, as well as for increased reliance on African institutions and practitioners for Africa-related disputes. So the question is, how do we change this situation and how do we increase this representation? So there is no easy answer for this. I think it's very complex, and it's not my ambition here to provide a definite answer, but rather to explore some of the initiatives that have been launched, most of them within the last decade or so. But even before exploring these initiatives, I think it's important to understand the current challenges that institutions and parties and counsel face when attempting to appoint arbitrators from an African background. So some institutions and parties argue that it may still be very difficult in practice to find African arbitrators that have the required experience, particularly in high stakes disputes. Although this is a bit of a chicken and the egg problem, because of course, if African arbitrators are not appointed, they will not gain this experience, which will in turn lead them not to be chosen. Another potential hurdle that has been mentioned is the plurality of legal systems. I've mentioned it before. In Africa, there is several legal traditions, so civil law-based traditions and common law-based traditions. So even in the case when sometimes an arbitrator from an African background seems to fit a particular case, these additional filters of, okay, but is he well-trained in the appropriate law, cause an additional hurdle. Finally, some African jurisdictions still are not very familiar with arbitration, and in order to develop a network as an arbitrator and as a counsel, it's important to have a strong international arbitration community. So I think there is still progress to be made in encouraging several African jurisdictions to develop these trainings and networking opportunities. So these are some of the hurdles that often come when trying to appoint an arbitrator from an African background. So now we're going to look at some of the recent initiatives that have been taken to tackle some of these hurdles. And as I mentioned before, most of them have been launched within the last decade or so. So this is a relatively new movement. Well, first of all, I think if we're part of this panel today, it shows that we're also responding to an invitation from REAL, which is an association. So I think associations have played and continue to play a key role in addressing the diversity gap in African arbitration. There are several associations, African Arbitration Academy, the African Arbitration Association, and of course, AfriCarb. And so they organize training events which promote recourse arbitration on the African continent. Several firms also have started secondments for lawyers based in Africa to spend some time in other jurisdictions. These lawyers go back to their countries with perhaps a better awareness of international arbitration and can then play in turn a significant role in advancing IA awareness in their home jurisdictions. Similarly to the Arab Pledge, which most of you will be familiar with in regards to gender diversity. In September 2019, the African Promise was established. So the African Promise is a pledge. It's available in French, English, and Arabic. And its goal is to improve the profile and representation of African arbitrators, and also to appoint Africans as arbitrators, especially in arbitrations connected with Africa. Finally, and I'll just mention it quickly, the African Arbitration Association launched the Model Bilateral Investment Treaty for African states. Two of its provisions are particularly explicitly include a formal diversity requirement in the establishment of an arbitral tribunal. So that's what associations, parties, and stakeholders have been doing. But institutions have also played a major part. In 2018, the ICC launched its Africa Commission to build capacity in the region and enhance awareness of and access to ICC's dispute settlement know-how. In 2022, similarly, it launched its 2022 Hold the Door Open initiative, which gives young African lawyers practical experience of arbitral hearings. And on its part, the LCIA has recognized that gender diversity is just one type of diversity and emphasized embracing diverse diversity. So those are some of the initiatives that have been taken to encourage diversity in international arbitration with an African angle. I'd like to mention, to conclude, just two other trends that can encourage diversifying the arbitrator pool. And these are regional trade agreements and local arbitral institutions. And I will just mention two regional agreements that I think will play a major role, and that's OHADA. So OHADA, which is the Organization for the Harmonization of Business Law, which is celebrating its 30th anniversary this year. OHADA has 17 member states, and it has a Uniform Act on Arbitration, which was enacted in 2017. And it also sets out a regional common court of justice and arbitration. That court is responsible for administering arbitration proceedings to ensure that they run smoothly. And it also has sole jurisdiction to grant or refuse enforcement of arbitration awards in OHADA countries. The CCGA also has its own rules. And I think that through the CCGA, which is therefore a regional African court in charge of overseeing arbitrations in the region, I think it'll have a key role in democratizing the use of arbitration in Africa and promoting African arbitration practitioners. Another example of an agreement that will play a significant role is and you probably all have heard about this, is the African Continental Free Trade Agreement, which is the world's largest free trade area by number of countries participating. And it has recently adopted its investment protocol in February 2023. We can think that by promoting intra-African trade, the AFCFTA will also boost the number of intra-African arbitrations being launched and in turn increase the number of African arbitrators being appointed and the number of African practitioners and counsel involved in these disputes, because many arbitrators begin their career as counsels. So the lawyers of today are probably arbitrators for tomorrow. Finally, the role of local arbitral institutions, arbitration institutions based on the continent, I think will be key in keeping and increasing the momentum for diversity in Africa. As of 2020, there were nearly 90 arbitration institutions located in Africa, and I think it's a sign that arbitration is gradually gaining acceptance and visibility on the continent. And having recently interviewed, for example, several arbitration practitioners in Senegal, several of them told me that the effective support of local arbitral institutions would significantly enhance recourse to African lawyers involved in international arbitration. So to conclude in just a few words, I would say that many initiatives have been and continue to be launched in order to improve the representation of African practitioners and arbitrators in international arbitration. Still, there is room for improvement, but just as in gender diversity, I think that efforts must be maintained over the long run, and that will necessarily result in better diversity. Thank you very much for the opportunity, and I look forward to answering any questions.
Thank you very much, Ledea, for this still underestimated perspective, right? African perspective. These are very valuable insights and initiatives. So our third speaker now, it is Professor Sarah Rudolph Cole. Professor Cole is Michael E. Morris Chair in Alternative Dispute Resolution at the Morris College of Law at the Ohio State University. She is the co-author of several books. She was previously the director of the program on dispute resolution at Morris. In 2013, Ohio State awarded her the Alumni Award for Distinguished Teaching. She was the chair of the AALS, Alternative Dispute Resolution section in 2015 and 16. She is also on the arbitration and mediation panels for AAA, the Financial Industry Regulatory Authority, and the state of Ohio. Professor Cole will be speaking about lessons on diversity and inclusion from American dispute resolution provider organizations today. Professor Cole, the floor is yours.
Thank you so much. And I'm very honored to participate in this, I'd say, seminar or presentation with such esteemed colleagues. And I hope that some of the lessons we've learned in the United States may be helpful to those who are focused on international arbitration. As many of you know, we have a somewhat checkered history with arbitration in the United States. We've used it for employment discrimination claims and consumer claims, and those are two areas where it's uncommon in other countries to use the arbitration process. And I think as a result of that, we may have encountered concerns about diversity among arbitrators even sooner than other entities might have. And you may all know as well that there's actually finally been some legislation which is changing a little bit the picture of employment discrimination arbitration in the United States. Last year, the Congress enacted the End Forced Arbitration of Sexual Harassment and Sexual Assault Claims, thus precluding employers from requiring employees to participate in arbitration of sexual harassment and sexual assault disputes. And those are really carved out because of the Me Too movement in the United States, which really focused on the issues related to arbitrating those types of claims. So I think the focus of the institutions, and I would say it was really interesting to hear Lydia's presentation, because I would say the movement for diversity in dispute resolution, at least with respect to arbitration, comes primarily from our institutions. There are bar associations who might, at least for a time, be interested in trying to improve diversity among arbitrators in the United States. But I'd say, other than academics and the occasional bar association presentation, the primary focus for improving diversity is coming from the institutions that provide arbitral services. And in the United States, that's primarily the American Arbitration Association, JAMS, which is headquartered and is primarily focused on California, and then CPR, the Center for Public Resources in New York City, all three of which kind of dominate the market for arbitration services in the United States. And I'll talk a little bit about what each of them is doing because of the pressure I think they felt to increase diversity in arbitration. And ironically, the real push, in addition to the Me Too movement, was a case that involved Jay-Z, who's if you don't know him, he's a famous rapper in the United States, and he owns a clothing company that was in a dispute with another company. And as part of that, they had AAA written into their contract, as many commercial entities do. And they were provided a 12-person list of arbitrators in this contract dispute, and it didn't include a Black arbitrator. And it is not to say that a Black arbitrator would have had a different decision than an arbitrator of a different background, but the fact that there wasn't a single arbitrator of color on the list was upsetting to Jay-Z and his company. And so they filed a lawsuit, which ultimately was settled. But I think that really triggered focus of the media in the United States, and then the institutions responding to the media to try and change the way arbitration looks in the United States. And I will say, like Lydia, there is promise. In, I think, 2013, that both AAA in particular has a report they issue every year that describes the diversity both of the arbitrators on their lists, but also the arbitrators who are actually selected to hear cases. And it's one thing, it's great to have a diverse list, but it doesn't make much difference to the world if those arbitrators are never chosen for a panel. But in 2012, AAA reported that 23% of its roster, its list of arbitrators, was diverse by gender and race. And I don't recall if they indicated how many diverse appointments they made. But at the end of 2021, they reported that 29% of their active panel members are women or racially and ethnically diverse. And 50% of the new additions to the AAA roster are women and racially and ethnically diverse arbitrators. And in 2018, they reported that they were making 27% diverse appointments. So while that might not, look like great improvement, it's improvement. And the trend is certainly in the right direction as they try to recruit more arbitrators who are racially and ethnically diverse, as well as gender diversity. One of the issues, I think, with their data is it doesn't separate women from minorities. And so it's hard to know exactly how that all shakes out. So it'd be nice to have that information available. And one of the issues is, like what Lydia said, that the problem with, and also what Professor Cadane said, is that historically, all the arbitrators in these institutions were white males, because that's the big law firms are where most of these arbitrators are coming from. And so, not surprisingly, they're mostly reflecting of the law firms, population, which is primarily white males, and still is today. We aren't seeing that much of a movement in the big law firms to having more racially and ethnically diverse lawyers or women, because in part there are maybe different reasons for lack of success in the big law firms, but that's a topic for another day. At any rate, we are seeing AAA and these other organizations looking in other places, other sources for more diverse arbitrators. And some of the things that they've done, in particular, AAA has focused on developing some pipelines for young arbitrators. They have for a long time had something called the Higginbotham Fellowships, which is named after a well-known African-American judge in the United States. So every year they recruit diverse applicants to shadow arbitrators, to receive training and mentorship, providing them networking opportunities, and getting them into the field of arbitration at a much younger age than they were before. JAMS and CPR and AAA all strongly encourage the businesses with which they work to consider using racially and gender diverse neutrals. They track their usage of diverse neutrals. CPR recently came up with diversity pledge, but they updated it so corporations that use CPR services can sign on to something we call the Ray Corollary here in the United States. And if you want to look at the website, I think it's RCI, Ray Corollary Initiative. But the idea there is that if the list that the parties receive is 30 to 30% or more diverse, and that means diverse by racial and ethnic categories as well as gender diverse, then it's more likely that a racially or ethnically diverse or gender diverse person will be selected as the arbitrator. So CPR committed to having a 30% diverse roster. And again, all of these organizations allow or encourage corporations to sign on to an agreement to have diversity among their arbitrators. Now, the sad fact is, though, recently Andrea Chandrasekhar at UC Davis did a study and showed that we already know that minorities and women are underrepresented in law firms in the United States, but they also are underrepresented even vis-a-vis lawyers, American lawyers, in the arbitration rosters. And the numbers of particularly racially and ethnically diverse arbitrators are so small that's actually not really significant in terms of how they're selected. So that's something that she's keeping an eye on and has recently written a new article about it. So I think hopefully keeping track of the improvements with respect to racial and ethnic diversity will help. One of the things I think is important to think about, and I'll finish with this, is when we talk about diverse arbitrators, we have to remember that you're not going to represent every form of diversity in one arbitrator or even 3 arbitrators. But it's important for there to be availability of these arbitrators and hopefully for arbitrators to be selected and given an opportunity. But the symbolism of having a diverse roster breaks the taboo, the old-fashioned notion that only older white men can mete out justice. And for us in the United States, particularly with our history of arbitrating employment discrimination claims, for us, I think the process has lost its legitimacy to some degree because we don't have enough women and minorities available to select from in those really important cases that impact those very groups of women and minorities. And finally, fairness notions, right? Well, fairness demands greater representation in the arbitrator corps for women and minorities. There isn't a law school class I've seen in the last 25 years that isn't at least 50% women. And we're seeing probably about 20% ethnically and racially diverse. So the arbitrator corps ought to be reflecting that more than it is. And I take my hat off to the organizations that really are trying to improve diversity among arbitrators, but it is a slow but steady progress at this point. So thank you so much, and happy to take any questions and have a lot more statistics that I could share as well.
Thank you very much, Professor Cole, for bringing us this rich presentation of the initiatives in America. Our fourth and last speaker was supposed to be the Secretary General of VIAC, Neil Lionwater, but she's unfortunately not be able to join us due to her professional engagements abroad. But we are very happy to have Patricia Netal instead. Patricia is a partner and co-head of the international arbitration practice at Knöpsel. She practices both as counsel and arbitrator in institutional and ad hoc arbitration proceedings. Patricia is the first female vice president of Vienna International Arbitral Center and has been a member of its board since 2020. She is the director of the Wilhelm Wismuth, the world's largest student competition in the field of international commercial arbitration. She is Austria's steering committee member of the Pledge for Equal Representation in Arbitration and is an arbitration academy, and she's teaching on arbitration matters at the Austrian Arbitration Academy. She is also a faculty member of the remote oral advocacy program at Delos. She regularly speaks and publishes on various arbitration-related topics. Patricia will be giving us today the institutional perspective on diversity. The stage is yours, Patricia.
Thank you very much. I'm very glad that I had the opportunity to step in today and join this talk about a topic that is very important to me. As you said, I'm the director of the Wilhelm Civis International Commercial Arbitration Moot, a student competition that has educated thousands of students in the field of arbitration in the past 30 years. We have just celebrated the 30th anniversary of the Wismuth, and I truly believe that it had an impact of increasing visibility of female practitioners and broadening the field regarding cultural diversity in arbitration. And we will continue to put our efforts in this respect. As the first female vice president of the Vienna International Arbitral Center, an arbitral institution that celebrates its 50th anniversary very soon, you can understand that it is also very important to me to increase diversity in arbitration. I will talk today about the institutional perspective, and in the past 5 to 7 years, I would say arbitral institutions have recognized the lack of diversity in the arbitration process, and that they need to take a more active role in enhancing diversity. Also to increase, and most importantly, of course, to increase the quality in the resolution of disputes. Most of the major and also regional arbitration institutions have implemented measures and incorporated certain standards to promote diversity. The most influential factor with which arbitral institutions can address the lack of gender and cultural diversity is the selection process, the selection of arbitrators. WIAG was one of the first institutions that signed the ERA pledge and started to publish the names of tribunals on the website. Other major institutions followed. And I think the visibility of tribunal names has a very positive effect also on the institution itself, as the institution wants to demonstrate that the users of their rules also, or that the institution itself can provide a larger pool of arbitrator candidates who are acting on arbitration cases. So definitely transparency helps diversity. And selecting arbitrators is, of course, not only an institutional task, it's in a majority of the cases the choice of the parties and the co-arbitrators who are nominating a chairperson. Looking at the 2022 statistics of in WIAG cases, only a third of the arbitrators nominated by the parties and the co-arbitrators were female. In 2021, even less, only 12% were female. So the trend is positive, and it's also reflected in other institutions' statistics, but we are definitely not there yet. As an arbitral institution, one can, of course, not interfere in the selection process of the parties. However, an institution can raise more awareness of the positive effects of a more diverse decision-making process and can also promote the visibility of female arbitrators, be it in events, webinars, at an educational level, training. So there are many ways where you can help female arbitrators to be more visible. Where the institution can directly increase diversity is with arbitral appointments by the institution itself. The board of WIAG is responsible for appointing arbitrators when parties or co-arbitrators fail to do so, or where the arbitration agreement provides for an appointment by the board. In order to make the pool of candidates for arbitral appointments more diverse, it's also important that the decision makers consist of a group of diverse people. And there is a sufficient number of people in WIAG involved in the decision-making process. WIAG has board members with different backgrounds, nationalities, who are practicing in various jurisdictions, and of course, it needs a good proportion of women that decide on arbitral appointments. The WIAG board currently consists of 19 members from, as I said, various jurisdictions. Members are lawyers, academics, and we also have a Supreme Court judge on the board. There is a rotating system implemented in the process, so I think the mechanism need to be adjusted to help diversity. And in this rotating system, there are always two different members in the board who are asked to make a proposal of 2 to 3 possible suitable candidates. The proposal is then presented with reasons why those two members of the board think these candidates are deemed suitable, and the board will then discuss the decision. I will then discuss the proposal to make a good decision. And also there is a requirement that in the proposal, female candidates are included. And in many cases, the female candidate will be put in first place to counteract the lower number of female arbitral appointments by the parties. This is a very conscious decision. There were 57% female arbitrators appointed by WIAG in 2022, which brings us to an overall participation of female arbitrators of 44% in all WIAG cases. And I think that is already a very promising number. And I think with ongoing efforts and further improvements in this respect, we're heading towards a good balance. Arbitrators in VIAC cases come from various jurisdictions, dependent, of course, on the specifics of the case and the specific requirements for the case. And taking into account that VIAC has a regional focus in CE and SEE region, there are about 25% of arbitrators coming from CE, SEE, and CIS countries, and nearly 18% from Western Europe and the UK. It was therefore important that we added members from the CE region to the board of VIAC to enable us, that it is not just an Austrian institution, to enable us to rely on a broader pool of arbitrators from more jurisdictions when it comes to arbitral appointments. We also created at VIAC the VIAC CAN initiative that consists of VIAC community ambassadors, so that the VIAC network covers many more regions and countries with ambassadors from each country to whom we can reach out if we need to find qualified candidates in those regions. We continue to explore how to become better, and there is always room for improvement, also of internal procedures to establish a more diverse environment. And we are also keen on exchanging experiences with other arbitral institutions. And I personally think this is a topic that needs cross-institutional cooperations, as we all can benefit from each other's initiatives to make dispute resolution services better by a more diverse environment.
Thank you very much, Patricia. Thanks a lot for this very interesting information about VIAC and what VIAC has been doing and what you are thinking about doing in the future. And thanks a lot for this ongoing effort as well. So I'm very conscious of the time. So I will just start the Q&A session. I have personally a lot of questions, so I will start with my questions. To anyone that would like to answer it. So I will start with a more general and also a little maybe provocative question. There are some critics addressed towards the efforts for diversity in arbitration, according to which these efforts might decrease the quality of decisions. I do not agree with that, obviously, but there is a question that comes to mind when we hear this statement. Does call for diversity really need to be justified, or is it really required to prove that actually a diverse panel can lead to better decisions compared to a more homogeneous panel? So I'm thinking about gender-based diversity, but also ethnical, religion-based, etc. So you can take it in a broad way when I talk about diversity here. Do we really need to prove that a diverse panel would lead to a better decision? Yeah, please.
I'm happy to start off with that. I think that it's a challenging point to prove one way or another, because of course we don't know what goes on when arbitrators talk among themselves. Personally, when I've been a member of a 3-person panel, I find the mere fact that I'm having the ability to have conversations with other arbitrators very helpful in just developing my thinking about things. And I can't say with confidence that my opinions are different because I'm a woman, but I think for the reasons I mentioned earlier, where we're just talking about the legitimacy of the organization or the process of arbitration, that to have 3 white men preside over a panel or one every single time there's an arbitration suggests that other people are not from different backgrounds are not competent to make these decisions or capable. And I think that in and of itself is a very negative message to send, and actually very surprising in my mind that corporations, at least in the United States, emphasize and focus very heavily on diversifying their workforce, but then somehow sort of offload the responsibility to their lawyers to select arbitrators, and all of the issues about or commitment to diversity goes out the window. And I think one of the things that institutions can do is emphasize to corporations that their commitment to diversity shouldn't end at their hiring practices. It should continue when they have dispute resolution processes at issue. And I've certainly seen a fair amount of writing about diversity of viewpoints does enrich discussions and results in better decision making. That may be more speculation than empirically provable, but it seems intuitively correct to me.
Yeah, thank you very much. So this argument on legitimacy is definitely should surface. I think at this stage as well. So another point that I'd like to mention, when we talk about diversity, gender imbalance has been considered as a problem in arbitration since a few years, we can say, and it has been considered as a problem in arbitration that should be addressed. And we can say that some progress has been made in this regard, but the case for ethnicity, religion, race, nationality imbalance seem to be in some cases forgotten. How can we raise the awareness to the imperfection of this approach, maybe this one-sided approach, without really shadowing the need of progress in gender imbalance? It's a delicate question. How can we raise the awareness to these questions as well? So it also includes the problem of intersectionality, because this is one of the other problems that I see that is not really addressed or a bit forgotten as well in this in the debate on diversity and inclusion. So which actors would be responsible of raising awareness to these questions, according to you? Yes, Patricia, please.
I think that all actors involved should work on a better awareness. And first, the parties. Yeah, I mean, arbitrators are service providers. Yeah, it's the parties to a certain extent, and then in majority of the cases have the say of who they choose as an arbitrator. And these are in most of the cases lawyers, yeah, counsel who are advising clients. But what I see is more and more an influential behavior by the companies itself, yeah, in-house counsel, who are also starting actually to demand more diversity in the arbitration process. And I think that's a very good development. Yeah, I mean, they are the actual users of the services. And I would say we have to start, or we have to enhance the educational level. Yeah, the more practitioners we have in as many as possible jurisdictions, yeah, we can increase the visibility, yeah, and we can increase actually or enhance, yeah, the service, yeah, in this respect. And I think the more practitioners you have, the more qualified people you have, it's easier to enable a selection.
Thank you very much. On another note, we have discussed pipeline issues. I think Ledea, she mentioned it in her speech as well. So we have this chicken and egg situation. So one of the arguments of parties or councils not appointing people from certain backgrounds is to say that they are not really in the pool of candidates, right? So this is called pipeline issues. And is there a problem of accessibility to international arbitration from people from certain backgrounds, or is it only certain type of people? So people of a certain background are attracted more to international arbitration. How can we render arbitration, international arbitration, more welcoming and more accessible to people from different backgrounds. So when I talk about different backgrounds, I mean diverse backgrounds, again, in a general way, in a broad way. Yes, Patricia, please.
Sorry, I think Lydia raised her hand.
That's okay. I can go after.
Yeah, I think it takes a lot of initiatives to help that improvement. Those are sometimes private initiatives. Yeah, I know many professors in the US who have taken up initiatives to promote students in the Arabic regions and to help them to participate in educational programs. So there are many international other initiatives, law firms that offer funds for students to participate in the program, because to a certain extent it's about money. Yeah, it's about the financial possibilities of universities or teams to participate in such programs. And then I think also states can help to a certain extent to improve the educational system and to open it to as many as possible. But of course, I think there's not just one way to go. I think it takes many initiatives from various stakeholders to help to make the arbitration field more diverse.
Yes, thank you, Lydia.
Yes, and just to add on to what Patricia has says, I think all actors have a role in increasing diversity and including diverse profiles. I think law firms have an important role in making sure their workforce is diverse, because, as I mentioned before, I think our future arbitrators are our current lawyers, our current counsel, and so the more experience they have as counsel, the more we can diversify our workforce, then the more we're going to diversify our arbitrators tomorrow. Again, I think there are lots of initiatives being launched that are going in the right direction. I think that in addition, I think there are good education systems in a lot of African countries, but I think arbitration is not as well democratized. And so I think the role of arbitral institutions locally will be crucial and in advancing this diversity requirement from all countries.
Yes, please, Professor Kino.
I think part of the problem is structure. It's the imbalance in the economic standing of the parties. It's basically the creditor's justice. So, especially if you look at the complaints in Africa, the arbitral tribunals is the way they are because the form contracts provide for default of appointment in LCIA or ICC. It is the lender's justice, right? The money comes from Europe, the project is implemented in Africa, and the form contracts make sure that the composition is in the way they like it. So in the absence of this, in the presence of the economic imbalance, it's really very difficult to address it. That's why it seems really stubborn over the decades.
Yes, definitely. There is this role of power dynamics, right? Based on financial situation, has a big part in all of that. I think I'm going to be ending with this last question because I'm conscious of the fact that it is 7 here in Ireland. So what about blind appointments, or at least, for example, hiding the race, the gender, or the ethnicity, the religion of the arbitrators? Some kind of a standardization of the CVs when the parties are appointing the arbitrators. Could it help, or should should we really need that, or what are your opinions on that, in order to achieve full objectivity in the appointment of arbitrators? Yes, Professor Cole.
So it's really interesting, and what Professor Cadane said makes a lot of sense. In the United States, the institutions themselves, who are always written into the contracts, years earlier, are the primary movers on the diversity front in the United States. So that I think is pretty critical. One of the things that AAA has done is with consumer disputes, so where a credit card customer or something along those lines, no matter how much that claim is for, AAA has the entity that's paying for the arbitration, which is the business, agree to an appointment from what we call the national roster. And usually those are fairly experienced arbitrators who are willing to do these cases. And so it's not exactly a blind appointment in the sense of the parties not knowing the race, ethnicity, or gender of the arbitrator, but they just get an appointment like we have in labor arbitration here, where you agree to a panel and then you get someone from that panel. And I don't know if that would be acceptable in international arbitration. These tend to be lower value claims, even though they can be greater. But I've advocated for that in the employment discrimination context too, that if you're generally accepting of the people that AAA selects for its arbitrator roster, why not just allow a random appointment rather than one where the parties select? So curious if that's true in international, or would be, well, I assume it's not true in international, but whether it'd be welcome.
I think, Patricia, you want to add something? Do you?
I think it's an interesting idea to have a blind appointment, but in many cases, the parties feel only confidence if they know the person, if they know their arbitrator. And often they also want to see a photo if you advise your client of the person. So there is a certain need that or parties feel they build confidence if they see the person who will decide on the dispute. And nationality plays a role in many cases, because parties assume that certain nationalities, or you don't want to have the nationality of one of the parties if you select your chairperson, for example. You want to understand the person, you want to know the qualifications, and sometimes the cultural background is also very important, because you assume a certain understanding for a regional dispute, for example. So I understand the idea, and I find it really interesting. But for high volume cases, I would think it is difficult then to get the confidence of clients in selecting the arbitrator that way.
Yes, thank you very much. Unfortunately, if they need a photo, it's it's always that it's gonna be a bit complicated to hide some information. So if no one wants to add anything, I am about to close this session. I really want to thank all of you, because I think it was a very thought-provoking event. This topic is really important, and it's really close to my heart as well. So thanks very much for having accepted our invitation. I'd like to also thank Arbitration Channel for hosting this event. They've been really great for the organization of this event. I'm positive that the discussion on the topic will continue, will have to continue, and at least I can guarantee that as real, we'll make sure that it continues in the future. So thanks to everyone, and see you soon.
Thank you.
Thank you.